Hello, welcome to today's Estate and Trust Administration webinar presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. Hope you're having a great Friday. Looking forward to the weekend and happy holidays to everybody out there. How this will work today, if you're new to our webinars, and welcome, we're glad you're here if you are. You are on mute, so when you have questions, please note them in the questions panel in the right-hand portion of your screen, and we'll take time throughout to address them. You received the presentation along with two checklists Steve will reference yesterday from me by email for your convenience to take notes on if you wish. Now for CFPs and CPAs, as always on today's webinar, you may receive 2 continuing education hours for attending, and per attendance requirements, please email me your board ID, and for CFPs only, I also need the last 4 digits of your social security number as soon as possible so I can submit my required reporting to get your CE approved, and I know you want that. So everyone will also receive a post-webinar feedback email right after the presentation, and we ask that you please just take a couple minutes to fill out this simple survey to offer us some valuable feedback about the presentation. It's also a great time to request a consultation with Steve for planning needs that your family and you have, and we look forward to being a resource for you now and in the future. I'm also going to stay on the webinar for a few minutes after the call. If you have any non-legal needs that you wish to discuss, if you want to set a time to meet with Steve or have any other questions about our firm, I'd be happy to answer those for you. So very briefly, an overview about our firm, and I'm going to share my screen here for a couple minutes before we get started. We were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We have a number of different practice areas here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, which is why you're here today, business law and succession planning, guardianship and litigation, and tax planning and asset protection. 7 attorneys, 12 staff members in 5 locations, and we are growing. Our mission, as always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. And we focus on education a lot here at the firm. Through our planning processes with our clients, we offer over 100 educational workshops and webinars in the communities we serve each year. And we also have an accredited client care program, the only such program in the state of Maryland through the Client Care Academy in Boston. We also focus on the ideals of client education, collaboration, and compassion with every client, every time, so you should expect nothing less anytime that you work with us. A little bit about Steve. Steve has been an attorney for the past 20 years, focusing on elder law, special needs planning, and estate planning, with a focus in the areas of tax planning and asset protection. He is a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. He was last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association, a very seasoned speaker, presenting at about 75 webinars and workshops, conferences, and continuing education events every year. Also named to the Maryland Super Lawyers list for a 5th time in 2020, and I might have an announcement on Monday about his Super Lawyers nomination for 2021, so stay tuned about that. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charity he founded in 2014, and I'm very privileged to be the executive director of that charity. If you'd like to learn more about our initiatives and how we work to better the lives of our student musicians in the communities that we serve. So, with all that being said, we're going to go ahead and get started. We have a poll that we'd like you to participate in, please, for just a minute, which I'm going to pull up here. And if I can find it, there it is. The question is, what has your experience been with estate and trust administration to date? So the responses are who you can choose from. I have been the executor of an estate in the past on my own, or as an executor, I sought professional guidance throughout. I may be asked to be an executor of an estate in the future. I want to keep my planning in order to keep costs down in the future. Or lastly, I'm an advisor here to learn to better serve my clients. So if you can choose the answer that best suits you, we appreciate your participation to get an idea of who we have on the webinar today. And then we'll get started. And it looks like most of us have cast their ballot here. We have 8% saying I have been the executor of an estate in the past on my own. 12% saying as an executor, I sought professional guidance throughout. 35% saying I may be asked to be the executor of an estate in the future. 19% saying I want to keep my planning in order to keep costs down. And lastly, 27% saying I'm an advisor here to learn to better serve my clients. So a varied group, Steve, that you have to speak to and educate. So I'm going to turn the controls over to you. Just a second, you should see that button pop up.
All right, Jeff, good morning, thank you. And I am looking for that button now. I see the poll. Let me get rid of my slideshow here just for a second.
There's that poll out there, there we go.
All right, now I'm looking for the button. So let me get my slideshow back up.
Here, let me try that button again for you.
There we go. Thank you, Jeff.
Okay.
All right, so let me go to my slideshow. Good morning, everyone, and welcome to our quarterly Estate and Trust Administration workshop. And it's my privilege to be here with you again this morning. Happy holidays to everyone. I want to say it's a beautiful day outside. I'm sitting here in our comfortable conference room in Columbia. I hope you're comfortable wherever you are. And we know you have many things that you could be spending your time and attention doing this morning, and we appreciate you being here with us. We know that many of you are facing challenges right now, either personal challenges because of COVID-19, business challenges. We are all having to social distance and the upcoming challenges of the winter. And we also know as we present this material about the administration process that it has to do with, of course, end of life and planning for end of life. So we want to be sensitive that many of you have suffered losses. I spoke to a new client yesterday who has lost 2 or 3 family members overseas to COVID-19. So we want to be very sensitive to the fact that this is very real and relevant information. We're going to try to keep it light because it is such a serious subject matter. But I'm also going to say our goal is for you to walk away from this, no matter what your level of experience is. And thank you, Jeff, for that poll, which tells me some of you have been trustees or personal representatives or executors before. I was very interested with that on that one particular statistic that 19% of you, I believe it was, just want to make sure your administration is as smooth as possible and you want to understand what is involved at end of life administration. So I know we have a varied group and probably a very intelligent group. So I'm going to try to not disappoint and give you a good overview. Now remember, this is an overview of trust administration post-mortem at death. And it's not meant to be an administration during life, like managing or administering a trust for someone during lifetime. This is not meant to be that workshop. So I just want to be very clear about that. And remember, we're going to give a broad overview. Estate and trust administration is a very interesting and many times enjoyable field of endeavor. It's complex, it has many nuances, so we're not going to attempt to be able to answer all questions or be able to address all issues, but this would be a high-level overview. But I promise you will probably know 95% more than anyone you know knows about estate and trust administration at the end of this webinar. And of course, it's recorded, and it will be recorded and available to you as well. I want to be sure to thank Jeff, my longtime friend and colleague here at Elville and Associates, for helping put on these webinars. Without Jeff, we would not be able to do this. And Jeff is an expert moderator, so I want you to feel as part of this process that you can ask questions at any time. We're going to be stopping periodically to take questions. Now, on the other hand, we have to get through the material. But just know this is an informal type of process where we want you to feel free to participate. And when you do participate, of course, it helps us tremendously. I also want you to know how this is going to work today. So many times we get feedback, and we appreciate your feedback about how we get this information across. So what we've heard over and over is that participants in these webinars attendees want to know about the actual process. They want to work through some actual examples. So I'm going to use some familiar examples that I sometimes use in these workshops. I'm going to give you the facts and circumstances of these cases. I'm going to give you 4 cases. I'm going to give you a broad overview of estate and trust administration, and then we're going to circle back. We're going to circle back to those 4 cases, and I'm actually going to walk through the overview of how I would approach the trust and estate administration of those particular estates and trusts. We're going to go through 4 examples. So that's my goal today, is to walk through the broad information, give you a sense of what these examples are, and then hopefully you have this available to you. You'll see here, these are checklists. And of course, there are many checklists for estates and trusts and estate administration. These are just sample checklists. We're giving you one for estate administration. We're giving you one for trust administration. If you have these handy, I want you to get them in front of you if you can. We're going to refer to them, and I'm actually going to walk through some examples with you. If you don't have these, I hope you will send Jeff a message and he will get these to you. But we're going to work through these actual examples. All right, well, again, we're going to get started, and here we go. And thank you again for being here today. Happy holidays. All right, and we go to my first slide. All right, so today we're going to unravel the mystery of what happens after the death of a loved one. This is a mysterious thing for some people. We get asked a question all the time. And now these are questions coming from people who have trusts. What happens at my death when I have a revocable trust, for example? That's one of the biggest questions we get in estate planning. Bullet point number 2 here, we want to minimize confusion, and we want to support clients and family members at a time of crisis, okay? So know that this is a very big part of administration. We want to know what the legal processes are. What are these step-by-step processes that need to happen? What are practical steps, not just legal steps? What are practical steps following death, okay? We're going to examine significant problems in legal and tax issues that advisors and clients need to be aware of. And I know we have some advisors on this call, or this video. We have probably some financial advisors, and we may have some CPAs on the call as well. And how do personal representatives, trustees, financial advisors, CPAs, attorneys, how can they best work together to support a loved one or your family at a time of crisis? And as we work through this, I want you to know that at Elville and Associates, we are not expecting you to handle this on your own. Many of you are clients that may be on this call, or prospective clients. One of the things that you are probably depending on is your law firm, your attorneys are going to be there for you. We take that very seriously here in our succession plan. Should certain attorneys no longer be practicing law and the firm continues after the death of an attorney, speaking of that event, we know you're depending on having guidance. So we're here to give you guidance. We're here to represent a trustee or an executor, personal representative. We're here to help you through the process, to do most of the work, but we know many of you are interested in this process yourself, and you may choose to have family members take care of these issues. maybe in conjunction with an attorney or a CPA to help you through the process. But we are here and we want you to know that. We also have our branded name for our estate and trust administration department called the Waypoint Trust Group. We also have just our general approach through our estate and trust department. So one of the client's greatest concerns when they are doing estate planning or elder law planning or special needs planning is, how is this trust or will in a probate situation going to be administered? And remember, in probate, we're going to talk about that, probate is the process of proving a will to be valid. So if we have a will, we know that there's going to be probate if we have probate assets. What are probate assets? Probate assets are assets that have no joint owner, they have no beneficiary, and they were owned individually by someone, meaning they're no joint owner, and it's going to pass through probate. Now, in some states, probate is not as onerous as it is in Maryland. For example, I understand in Virginia, probate is rather simple compared to Maryland probate. But in Maryland, whether we have a will or whether we don't have a will, if we have probate assets, assets with no joint owner and no beneficiary, those assets are going to go through probate before distribution. Good definition of probate, in my opinion, is probate is the process of proving a will to be valid, and letting people have notice. And we're going to talk about that. Now, trusts have to be administered also. So there is a little bit of a mystery here. Some people think that a revocable trust, and remember, a revocable trust is nothing more than a substitute for a will. In basic estate planning, we can have a will or a will substitute. A revocable trust has to be administered. Now, in theory, a revocable trust administration is very quick because there is no probate if everything is properly funded and aligned in the revocable trust. There is no probate. But practically speaking, there is still a process of administration, and we recommend to trustees that they follow that process because trustees have liability. Personal representatives have liability, and we want to make sure that everything is administered whether we have a will or a trust. Now, there are times under certain circumstances where trusts can be administered much more quickly, but generally I want you to think in terms of both probate and trust administration, which is non-probate. I want you to think about it as a process. And of course, there's a transitionary period. Some people are worried about what happens after my death? What happens after the death of a loved one? And how are we going to get from point A to point B? So there is a transitionary period where we have to go from, let's say, a living trust, the revocable trust, to an administrative trust and getting all of that established, or with a will, getting the probate estate open. So there is a transitionary period. The best thing to do is to understand this happens all the time. This is not something to panic about, but it is something to be prepared for, and that's why you're on the video today. Who will be there for the surviving children and spouse? So we want to be thinking about that. What do you do? What are those step-by-step processes? I know many financial advisors are concerned about making sure their clients have a step-by-step process guide. Hopefully this will be helpful today. And again, we've talked about process here just in the last 5 minutes. Everything in administration, whether it's probate or not, should be driven by a process, okay? And we're going to talk about that. And again, preparation through planning and organization, and that's why you're here today. So I'm going to give you some case examples. I've tried to characterize these in my own way as the following. There's a plan-specific kind of administration where the structure is very clear. Or maybe there's an asset-specific kind of administration where there's many retirement kinds of assets, and maybe there's non-probate assets that are situated strategically. And if I'm getting ahead of some of you already, don't worry about that. Just remember that this is to give you an overview. This is to get you moving in the right direction about administration. So we're going to have to get our minds around, probate versus non-probate assets as I talk about these examples. There might be a need-specific situation where there's a survivor And maybe the situation is different than we anticipated, because remember, the state and trust administration is not always predictable. There are always things that may surprise us. At other times, it's very smooth. I like to liken it to a symphonic event where someone is conducting the orchestra, like an executor or a trustee, and everything just makes sense. It's wonderful, and it's just all structured and it works out perfectly. But that's not always the case. And then we have fact-specific things where there was no plan or a poor plan, and the fiduciary, the executor or a trustee, has to make judgment calls. So my goal here is to introduce you now to these 4 fact patterns that we're going to come back to within the time that we have. And I'm going to give you a minute or two after each one of these just to take this in. So let's look at this particular fact pattern. We have a single person. We'll call him Felix. He was never married. He was age 77 at his death, and he has 1 child, Charles. So Felix, a single person, age 77, passed away. His son is Charles. At the time of his death, Felix had a residence. He had a CD and cash and checking. He had an IRA. Now, interestingly, he had savings bonds of a pretty significant amount, and we see this from time to time in administration. He had made no lifetime gifts. He had no creditors at his death. He had Social Security income, and he did have a will. Let's look at this. He had a will. Everything goes to Charles outright. So he had a simple will. I'm going to take about a minute here just to let you get your mind around this fact pattern. Felix, single person who passed away. So we're just going to take a pause here for you to look through this. If you have the ability to make some notes, I encourage you to write them down. If you see something here that you look at and you say, well, that makes sense, but I've got some questions about how that works. We'll take about another 30 seconds or 45 seconds here to let you make those notes. Okay, in the interest of time, we'll move on to example number 2. I promise we will come back to this. Now here we have a married person, and I've named this couple Jack and Janet. So Jack and Janet are a moderately successful couple, and Jack is age 69, and he has a surviving spouse. So Jack has passed away. There's 3 children. We have no indication that they are not healthy, so they are probably healthy children. Janet survives. Let's make the assumption that she's of a similar age to Jack. Now, when Jack passed away, he and Janet had a residence, $550,000. They had checking, savings, and CDs, cash. They had retirement plans. Jack had a 401k, let's say. He had IRAs, and combined, these IRAs are $900,000 and $200,000. And of course, Jack has the 401k. There was a joint brokerage account. This is very understandable, very common, very predictable, $600,000. There's a life insurance policy on both spouses. Jack has the bigger policy. Now notice here they have a second home. They have a Delaware residence. So they loved being down on the Delaware shore, let's say. They had a lower, slower life in Delaware. So we have to think about that. What does that mean? Now, there were no lifetime gifts, no creditors at death. Jack had Social Security income, and he did have an estate plan. Let's look at that at the bottom if you can see that. Jack had a revocable trust, Jack and Janet had a revocable trust, and look at how it was distributed. It's outright to Janet, so very simple. Jack wanted to keep things simple, but Janet has a disclaimer right. She has the right to make a disclaimer, and we'll talk about that. And you'll see at the bottom, alternatively, we'll talk about what happens if Jack had died with a trust where there was a formula clause. What would that mean to you? What is a formula clause? So let's take about 45 seconds to a minute to get our minds around this fact pattern and make some notes, if you want to, about this couple situation. I know this is very hands-on, and hopefully this is the right direction for most of you to get involved. Jeff, I'm going to stop for just a second. We've been going for a little while here. I just want to see where we are, if there's any questions yet.
I'm sorry, Steve, we do not have any questions yet. I've been sending out some of the checklists and the presentations to some of our later arrivals, so everybody should have the information that you're discussing right now.
Sounds great. All right, looking at my clock, it looks like we've been going for about 30 minutes, so I think we're on time.
Actually,
Now let's
sorry, Steve, we got one quick question that just came in, if that's okay. Sorry to interrupt.
Certainly.
So the question is possibly tangential, if I said that right, I apologize. How does one typically confirm if there are lifetime gifts?
That is an excellent question. Thank you. So remember, the whole point of me including that in a fact pattern like this is because when you are a trustee or a personal representative, we have responsibility, right? And we have the responsibility to make sure if there's any need for estate or gift tax returns to be filed, or and of course we have to do the 1041, which is the income tax return for the estate. That bullet point is about making sure that we understand whether or not we have an estate tax problem. Now, right now, we have an 11.58 million per person exemption from gift tax and estate tax. So the way to do that would be you as the trustee or personal representative would send in a form to the IRS. It's form 2848. And you would become privy to the information about whether the decedent had ever made any lifetime gifts. So if they had made lifetime gifts, those gifts should have been memorialized by a gift tax return, which is Form 709. And if the decedent had made gifts but never filed a 709, that's probably something we would hopefully want to know about if we could ever find that out and make sure that that is something that we're cognizant of. Because remember, if the decedent did make lifetime gifts, that decedent had used some of their own lifetime gift tax exemption if it exceeded $15,000 per person per year. So the way you would do that is you would find that out through IRS records. Thank you for that question. All right, let's go to a fact pattern number 3, the death of the surviving spouse. Now, so this is the same couple. We've had a probate example. We've had a revocable trust example where one spouse dies. Now this is the death of the second spouse. So Janet has passed away in my example 20 years later. They still have the 3 children living, but now look what has happened. One of those children has been disabled through, heaven forbid, a car accident or a brain injury where they've suffered a debilitating injury. So the fact pattern has changed. Now, Janet is, at the time of her death, was living in a CCRC. She was living in a continuing care retirement community such as Asbury Methodist Village, Charlestown, Riderwood, all of those types of communities where there was a deposit. There was cash, savings, checking, $375,000. There was still an IRA, or IRAs, I should say, of $1.2 million. A brokerage account, look at the growth in the market. Their 600,000 has now turned into 1.3 million. Janet survived with some life insurance in her own name. And look what happened. Janet sold the Delaware residence and moved to Florida. There's a Florida residence, okay? And apparently that is a second home in this example. And again, no lifetime gifts. Her income was $2,000 a month. And again, she had a revocable trust at the time of her death, and it says to the children equally in trust. So this is a situation where at the time of Janet's death, 20 years later, she's leaving assets to children in further trust for their protection, okay? And I've made a note here of, do we need to decant any of those trusts? I mean, remember, each child is going to get a trust for his or her own protection, but now one of those children is disabled. So what does that mean? And what is decanting? So that's a little bit of a different fact pattern there. It's a little bit of a twist. I'm going to give you a minute to wrap your mind around this particular fact pattern, the death of a surviving spouse where both spouses had a revocable trust or two separate revocable trusts. Now the survivor dies with her revocable trust. I want you to make a note of anything that jumps out at you here. What is it that would jump out at you if you were the successor trustee of this trust and you were going to administer this trust after the death of Janet? What jumps out here? What are your questions about this fact pattern? Okay, as we can see here, we're really rolling up our sleeves and getting into the information. I'm going to go to the last fact pattern, which is a complete departure from the former two fact patterns. Here we have the death of a person. This is a person who is married but separated, and admittedly, this is a bit of an unusual situation, but I have actually seen situations like this. And at the time of this gentleman's death, his spouse lived in a very different kind of lifestyle in another state. And they have children, and one of those children is in bankruptcy. Okay, so a little bit of a humorous, in some ways, situation, but not so unusual. It shows that in administration, there can be all kinds of twists and turns. So this particular person died. As you look at the bottom of these bullet points, there was no estate plan. So this person, unlike the first example, this person died with no will, but he had probate assets. He had a checking account in his own name, small amount of cash in there, $3,100. He had an inherited IRA that he had inherited from someone else. He had an automobile in his own name. He had life insurance, but he did not have a beneficiary. So these are little twists and turns. He had savings bonds in his own name. And interestingly, which is a little bit of an unusual twist here, he had made lifetime gifts. He had some significant cash at another time in his life, and he had made a lifetime gifts of $500,000. He has $4,800 in a federal pension. So let's take about 45 seconds. What jumps out at you about this situation? A married but separated person, and some of the twists and turns of this fact pattern. And don't worry, there is no such thing as failing a test in this webinar. Everybody will pass. It's just, this is my method of teaching as we try to give you something of value here to take away. All right, thank you for thinking through those 4 fact patterns. Now, we're going to come back to them. We're going to work through them with these checklists. And if you don't have the checklist, I promise I will make everything as visible to you as possible through this medium. And let's just go through the general presentation. I promise I will come back. Now, some of these things are non-technical. We want to have empathy for clients and their situation. We want to know what kind of family support does this client have. We want to make sure there's not an unbelievable meltdown, which of course can occur. These things are very non-technical. If you are a professional, we want to have your whole firm involved in the support of the family. We want people to be aware of the losses that have been, that loss that has happened. We want to be creative. We want to be informed about resources. Many of you who are non-professionals are on this call today to try to find out more resources. We want to be informed if we're professionals to be able to pass along these resources at a time of crisis. We want to be able to refer and act as a counselor and coordinator for those of you in positions of professional leadership. Now, one of the things I see is I see many clients who are survivors. They are rushing to try to get things taken care of, but I want to say that within reason, there's really no hurry. So many folks put themselves through a lot. They put themselves through a lot of torture and anxiety for a period of a couple of weeks, at least 3 weeks. There should be no hurry in addressing some of these things. Now, there are always exceptions. Let's say someone passes away and they owned a lot of rental properties, or there are investments in a time of turmoil in the stock market. I'm not going to say there aren't times where there needs to be some hurry, but generally speaking, the survivor, if there's a surviving spouse, does not need to be in a tremendous hurry or put themselves through the anxiety of facing things that they're not ready to face. They need to take care of themselves first. The family members need to take care of them, and then things can be addressed, usually in the order, in a normal order. We want to assure clients and fiduciaries that the advisors will be working together. They're coordinating. That's not an easy thing to do. So we want to have an advisory team in place. Hopefully at the time of death, there is an attorney, a financial advisor, a CPA, and in some cases, there is some kind of a life care manager or geriatric care manager. We want to assure the client and the fiduciary that everything is in order if we are professionals. We want to make sure there are funds available. Many people are very concerned about this, about a transition period. Are there going to be funds available? That's something to talk about in planning. We want to make sure that final arrangements are pretty clear. Of course, that's part of good planning. For those of you that are on this call, where you're making sure things are as clear as possible. I'm going to say one word about this that has to do with during life. If we are revisiting documents anytime in the last couple of months, or if you're planning on revisiting documents in the future, we want to revisit your advanced medical directive, because not only does that usually set forth final arrangements, and we need to be as clear as we can, but there are reasons to think that because of COVID, we want to make sure that we're addressing things that we may not have addressed previously in the advanced medical directive, which I won't go into today. Some of you have seen that in my recent blog, but just know advanced medical directives, of course, have to do with life, but they usually also set forth the final arrangements. We want to assist clients with any family-related issues. We know that families are sometimes in turmoil, hopefully not, but if so, as fiduciaries, surviving trustees, surviving personal representatives, we want to make sure we're aware of those family issues. We want to send sympathy bouquets of flowers. We want to attend funerals and memorial services if we are professionals. And of course, this is common sense, but very, very valuable to the survivors. Now, let's talk about the legal process that takes place at death, probate versus non-probate, meaning what if we have a will or no will, or what if we have non-probate, which is generally speaking for administration, a revocable trust, or remember when the revocable trust becomes irrevocable, that's when it has to be administered. Or there could be another trust. There could be an irrevocable life insurance trust or a special needs trust that needs to be administered. So these are various types of administration of non-probate assets. So these are similar steps, but we want to use checklists, okay? We want to use checklists when possible, and organization is the key, of course. So the legal process, we want to look at the date of death values. Now remember, as we get started, remember that this is not going to cover all aspects of administration. I am here today to give you an overview. We want to just follow the overview and start to get a sense of what the process is all about. I run into people all the time that say, I'm in the middle of administering this estate, or I'm in the middle of administering this trust, and I'm just lost. I feel like I went out for a drive and just got lost somewhere in the middle of nowhere. So it's very important to have an idea of the structure of what this is all about. So we start with date of death values, basically. So we have the date of death, we get letters of administration, and this is a probate estate now, and we get letters of administration from the Register of Wills. Remember, all counties in Maryland have a Register of Wills, and all counties have an orphans court except for 2 counties, Harford County and Montgomery County. So the Register of Wills is going to issue the letter of administration, and that's going to give the personal representative the authority and the power to go ahead and take charge of the assets. So we want to marshal or take charge of all the assets. And as we're going to see with the checklist, in a series of about 3 months, we have an inventory and an information report due. We're going to talk about what that is. We have alternative valuation dates. We're not going to spend too much time on that today, but our main thrust is to understand we want to know what the assets are at death, how they were owned, and how much they were worth. That is what we want to know. That is our baseline, okay? Claims against an estate in Maryland are going to run for 6 months from the date of death, not the date that you open the estate. This is very important to understand as a personal representative. Spousal elections. Now we have a new augmented estate in Maryland, and that's beyond the scope of this discussion, but just remember, spouses have a right of election, and we're going to be talking about that in a different webinar. We have guidelines for when tax elections have to be made. One of those tax elections is a disclaimer that we saw in Janet's example. We're going to talk about that. Federal and state estate tax returns are due at a certain time. And of course, they can be extended, but the tax is due if there is any tax within 9 months, generally speaking. Q-tip elections are made. This is the marital trust election. The qualified terminal interest property election. This is made on the estate tax return, which is Form 706. This is not going to be something that's going to happen in every estate, but that has to be done within 15 months. The portability election. Remember, this election has been around now for about 8 years. I don't know if we will have portability going forward, but remember, portability is the ability of a surviving spouse, I'm talking to spouses now, a surviving spouse to choose to port the estate tax exemption of the deceased spouse. So if the deceased spouse died in 2020 with an 11.58 million exemption, the portability election allows the survivor to port that 11.58 million in addition to his or her own 11.58 million. That has to be done within 24 months. The first administration account in an estate has to be filed within 9 months. And we're going to talk about that checklist. The second administration account, if we're not done within 9 months, there's a timeline and so forth. And then you'll see some things down here about releases of liability and so forth for personal representatives and trustees. Retirement plan accounts, there's a certain timeline we need to be thinking about. Let's go ahead and get that out on the table. So beneficiaries are finalized by September 31st or September 30th of the year following death, of the year following the date of death. So we have a series of timelines starting in September, October, and then finally December, when retirement plans have to be claimed and separated into separate IRAs. There's a timeline for that. Generally speaking, the personal representative or trustee is responsible for that. And then we have to know about the Secure Act and how has that affected how retirement plans are distributed, who is eligible for deferring lifetime payout or required minimum distribution for IRAs and who is not. Most people are not eligible to defer anymore. Most people can only take those IRA distributions for inherited IRAs up to 10 years, and then the IRA has to be depleted. We have to understand all that as a fiduciary. Now, the fiscal year has to be selected, and there has to be a fiduciary income tax return. This is called a 1041. And then those 1041s have to be filed at certain times. And then if we have a taxable estate or an estate where we had to worry about a Maryland or a federal estate tax return, we are going to be concerned about when we receive the closing letter and so forth. So this is a very high level overview to get the process of probate into your mind and to really understand that the structure of things is really to start the transitionary period, be appointed as a personal representative, take charge of the assets, value those assets, secure those assets, and understand that you have responsibility throughout the administration process. Now, there's many nuances to understand that creditors have a right to make a claim, to understand that you need to open an estate checking account, and all of those simple or straightforward things that if you're represented by an attorney, you're going to be reminded of those things. You're going to be guided with those things. If you're not represented by an attorney or CPA at that time, you're going to want to follow strict guidelines set forth by the Register of Wills. Jeff, I'm going to stop for just a second, see if we have any questions.
Thank you, Steve. We do. The first question is, why or in what circumstance are there separate revocable trusts for spouses? If there are two trusts, how do they title houses? Yes, how do they title houses?
Great question. So every case is unique. There is no one set formula, but remember when it comes to revocable trusts, and this is more of a planning issue, but it's also something to know about as a fiduciary, there can be a joint family revocable trust, and generally speaking, talking very generally, it's considered to be a 50-50 ownership of the spouses. Does not have to be, but it is considered to be kind of a 50-50 joint ownership. Husband and wife property, let's say a residence, can be titled in that joint trust, and the joint trust can own that property, which was husband and wife. When it's transferred into that trust under Maryland law, it can retain, if it's properly done, it can retain its creditor or asset protection as husband and wife, tenants by the entireties, even though it's owned by that trust. Now, let's say that couple went to an estate planner, and remember, joint trusts are just a choice. In the traditional sense, each individual spouse, husband and wife or wife and husband, or spouse, has their own individual revocable trust. So purists believe that it's better for people to have their own individual revocable trust. So whether it is a joint trust or two separate trusts, a spousal unit should, in Maryland, should title their spousal property, tenants by the entireties, into the two separate trusts, 50-50, or into the joint trust, but it would retain an umbrella of protection as husband and wife property, or what we call spousal property these days. Now, not every circumstance is the same, and not every spousal unit is going to transfer their house into the revocable trust, but most of the time that would be the case. Thank you for that question.
Thank you, Steve. Those are all the questions for now.
All right, so now we're going to go into non-probate for the next 10 minutes or so, and we're going to follow up with the balance of the presentation and come back around 11 o'clock, which should give us 30 minutes to work through those examples. So in a non-probate administration, and what do I mean by that? I mean, typically for our purposes, a revocable living trust. So let's say on the death of a surviving spouse, or on the death of a single person who was never married, either one, we want to do many of the same things. And this may be surprising to you. Why? Why do this when the assets could just be distributed straight out? Steve, if the assets are in a revocable trust, Aren't they distributable immediately upon my death? The answer is yes, they are. The trustee could just distribute everything immediately. But we know trustees are going to be smarter than that. And in most cases where there are more than one beneficiary, especially, we want to be very smart, very methodical, and walk through a process, even though it's a revocable trust. So look at some of these similar duties of a trustee. We want to get date of death values. We want to provide notice to beneficiaries. Now, remember back in the probate process, which I didn't cover, the Register of Wills is going to ask you for a list of interested persons in a probate. Who are the interested persons? Who are the people in the will? Who are the people who would have received property if there were no will? That's a brain twister. But the Register of Wills has that information now that you are obligated to give them, and they are going to give notice to beneficiaries. Notice here, since 2014, you are obligated as a trustee to give notice to the beneficiaries of a revocable trust, for example. Now, do you give notice to creditors? That is a preference. We recommend that you do run notice to creditors. Most people don't realize that a revocable trust could be subject to the claims of a creditor. How do we know that? Because the Maryland Trust Act allows it now since 2014. So creditors have always been able to make a claim against a revocable trust. I have never seen it happen, but in theory, a creditor can make a claim. Since 2014, creditors can make a claim against a trust under the law, and it's very clear. Now, if we give notice to that creditor, we can limit the amount of time the creditor can make a claim and foreclose the claims of a creditor if they have not made that claim within 6 months. The spousal election. This slide, I apologize, should be updated. So if you're looking at this slide, the new augmented estate is now law as of October 1st. So we do have a new augmented estate in Maryland. I'm going to cover this very quickly. So the augmented estate in Maryland simply means this, and it's complex, and again, it's the subject of its own webinar. But the augmented estate now means, as of October 1st, 2020, that a surviving spouse is entitled to at least 1/3, and not just 1/3 of a probate estate, as was the traditional approach. The surviving spouse is entitled to 1/3 of many potential assets, almost all assets of the deceased spouse, not all, but almost all, and he or she is entitled to make that elective share claim. Now, there are many complications that will happen in administration because of this spousal elective share law, but the idea was to create a system of fairness to surviving spouses in situations where deceased spouses were not being fair and were trying to disinherit a surviving spouse, either intentionally or unintentionally. The good news is in elder law, the new augmented estate allows certain types of very advantageous planning for spouses where one of the spouses is ill. So there are many advantages to the augmented estate law. There are complications because of the augmented estate law. If we are dealing with a conventional situation where the deceased spouse leaves everything or most everything to the survivor, this is not going to be an issue. But you need to be aware there is a new augmented estate law in Maryland, and it will affect trust and estate administration. Q-tip election, again, if there was a marital trust left for the survivor, for example, the Q-tip election has to be made, whether it's a probate estate or a non-probate estate, as we're seeing here. Portability election is the same, disclaimer time frame is the same, and you see right on down this list here, retirement account timeline, the ramifications of the Secure Act. All of these things are similar to probate administration. Some of you may be disappointed when you see this. Well, I thought I had a non-probate estate and it was going to save time and energy and effort. Well, the answer is yes, it will. If you maintain your plan during life, make sure it's all properly funded and aligned with your assets, make sure it's updated over time. That's why we have our client care program. But you need to understand that an intelligent trustee will use a process, use a checklist, and remember when they get to the end of the administration, what do we know? They have to be accountable. They have to account, just like in probate. So we want our trustees to be accountable And the way to do that is to walk through a methodical process, whether it's probate or non-probate. Now, as I wrap up here with non-probate, remember, we are talking about getting released from liability. So many of you may end up serving as a trustee of a trust. And when you are ready to distribute assets, you may be inclined, as a very kind person or a very smart person, you've wrapped up everything, you're just ready to distribute the assets. Don't do that. We don't want you to distribute assets to anyone who has not signed off and said they understand the accounting, they understand what you've done, and they understand that they're releasing you from liability. Now, not everybody is going to do this. Some people are going to resist doing this, but 9 times out of 10, the beneficiaries want to receive their money and they're willing to sign. And by law, you're entitled to be released from liability when you have done your job and you're ready to distribute money. So we want to have them sign what I would call a release waiver and refunding agreement that says, you've received an accounting, you agree with it, and you're releasing me as the fiduciary, the trustee, from liability. And we strongly recommend that you do that. We do not want you to distribute assets to someone who has not signed off on this and can use the assets you distributed to them to turn around and sue you. So we do not want that to happen. And of course, we want you to do your fiduciary duty. Now, we know the 1041s have to be filed. This is the income tax return. Some of you might say, what is a 1041? Well, it's not the simplest tax return in the world. You probably would not want to prepare it yourself. Here at the firm at Elville & Associates, we prepare 1041s. Many of the CPAs that are on the call this morning prepare 1041s. So it's not something I would recommend the average person do by themselves. What does the 1041 do, in my opinion, in a nutshell? It accounts for the income from the date of death until the time of distribution. So remember, Uncle Sam does not care who pays the tax. Uncle Sam just wants to know, okay, up until the time the person died, that person paid their own income tax, let's say, on their 1040. But now at their death, their estate or their trust is going to be responsible for paying income tax on the probate assets, meaning the estate assets or the trust assets, from the time of death until the time of distribution. So when you think about it that way, that makes it sensible. The decedent paid their own taxes. Now the estate has to pay their taxes. And the way Uncle Sam accounts for that is through requiring the 1041. Now, what are the practical steps? Let's get back away from the technical, and then we're going to get to the examples. We want to schedule a meeting with a surviving spouse within about 30 days or sooner, whatever is reasonable under the circumstances. We want to coordinate with all the advisors. We want to use checklists. And remember, I'm being redundant here. Organization is the key, not only to the process, but to peace of mind. We want to have an inclusive process. What does this mean? Well, there are times when not all beneficiaries get along. And it's possible that we're going to be faced with a situation, you might be faced with a situation where the fiduciary has got to make a decision. Do I've provided information to the beneficiaries as I'm required to by law, but I don't have to give them things that they're not asking for, let's say, or let's say this person is potentially troublesome. This is a potentially troublesome beneficiary. Well, we have to use common sense, and we have to use whatever we think will work about whether we want to withhold information if it's not really being specifically asked for, or maybe we have a more inclusive process to try to minimize conflict. Sometimes conflict cannot be avoided, but my point is, generally speaking, we want to provide information, provide all information by law, and have an inclusive process. Generally speaking, this is a good idea. Many people get very concerned with a beneficiary who is troubled or is not represented by an attorney, and then there's a lot of anxiety in a process like this where someone says, oh, I'm going to go get my own lawyer. Well, it may sound easy for me to say because I practice law, but I think that you will find that 8 or 9 times out of 10, when that person gets an attorney, communications, which might have been a challenge, communications become easier. I'm not saying it's always a good result. Maybe there is a really awful person that they have hired as their attorney. Maybe it's just a horrible experience after that. But I have found many times when the attorney gets involved and now we have two attorneys talking to each other in a troubled situation, that is the first step towards starting to work things out. So I wouldn't necessarily fear the involvement of another outside attorney, although we don't want that if we can avoid it. We want to have due diligence about taking care of survivors. We want to encourage a methodical process, but not a rushed process unless it's absolutely needed, okay? And many times survivors want to address their own planning. And this is where I also see sometimes a rush of the survivor emotionally to do their own planning. It's okay, but we want to take very, very good care of that surviving spouse when he or she is pushing themselves hard to do things when they are still grieving. So again, organization and general readiness. What are document storage policies? Well, we have online storage, we have safe deposit boxes, we have strong boxes, we have fireproof safes. Elville and Associates is one of the only firms I know that still stores original documents. So most law firms do not store documents, but we want to think about this and how are the decedent's assets listed, their electronic assets. Do they have an electronic archive? Do they have a list of their digital assets? Are they using online services like Everplans? And do we have passwords? All of these things are part of the intentional process of making things work at the time of death. So if you're still obviously living and you have your own estate plan, I want to encourage you to think about these things. If you're dealing with the estate of someone or trust of someone who has just died, remember these kinds of things are what you want to look for to make sure you're covering all your bases as a fiduciary. Now let's talk about some of the most significant problems. And Jeff, I'm just going to take my time here. We're running a little bit late, but we'll go through the process of the examples nonetheless. So we want to review titling of assets prior to death. So this is part of what I just talked about, being prepared. We want to look at all titling. If you said to me, Steve, what is the most important thing in estate planning? I would argue it is this: how are assets owned at the time of death? How are they owned? That is arguably the most important thing. So we want to know how our assets are titled prior to death. And of course, when someone dies, how were the assets titled at the time of death? Valuation of all assets, big issue. Many people charge ahead in administration without realizing they have to get valuations, okay? And these valuations can be controversial. We want to make sure that it's transparent to all. We want to make sure that we're not distributing assets or retitling assets if we're a beneficiary on the other end of things. We want to, let's say a surviving spouse, we want to make sure we're not jumping the gun. Some people, someone dies and the estate plan is structured in such a way that certain things are supposed to take place, and a survivor will just take the assets and retitle them in their own name without any regard to what the documents say. So this is something that many clients are afraid of. How do I know that my assets are actually going to flow the way my document says it's going to flow? So there is such a thing as fiduciary responsibility, even if you're a beneficiary. So just we have to be aware of that. Inheritance tax. Inheritance tax in Maryland is due basically within a certain period of time for non-lineal descendants. So Maryland has an estate tax for state estate tax. It also has an inheritance tax, which is generally 10%. Now, Maryland eliminated the inheritance tax as to most beneficiaries, but for non-lineal descendants, for example, friends, if I left $100,000 to a friend of mine, that would be subject to 10% inheritance tax. If I left $100,000 to a niece or a nephew or beyond, that's my rule of thumb, even though that's not a specific way of looking at it. Nieces and nephews and beyond is a good rule of thumb. Those individuals are subject to 10% inheritance tax, basically. The portability election has to be made within 24 months, which is very generous on the part of the federal government. It used to be much shorter period of time. The Q-tip election has to be made within a certain period of time. So we want to make sure that we're making those elections. And the good news is the portability election and the Q-tip election are made on the same form. So that's generally not an issue. What is a failure to foreclose creditors' claims? Well, let's say we're advising someone who's administering a trust and that person chooses not to give notice to creditors. Even though I've never really seen in my practice a claim against a revocable trust, this person has failed to foreclose the claims of creditors, and now a big creditor claim comes out of the blue against the revocable trust. So that would be something that is a big issue. So these things on this slide right here, valuation, reviewing titling, making sure that we're not retitling assets after death too quickly, making sure we're addressing inheritance tax issues and so forth. We're going to cover this in the examples. Communicate completely with your advisor team. So if you're a fiduciary, you want to communicate with all of the people involved. We know people are busy. Professionals are busy. They tend to stay to themselves and do their portion of the work without a lot of collaboration. So we don't want that to happen. So we want to maybe designate a quarterback of those people in your advisory team, someone who's going to take the bull by the horn, so to speak, and make sure everyone is communicating. You may have to do that as the trustee. Again, we want to make sure during lifetime that we're doing as much as possible to make things smooth. Again, back to our client care program, where we're encouraging clients to get everything in order the right way and make things easy for fiduciaries. Look at the bottom here where it says, encourage the use of a memorandum of intent. I spoke to a client last night and he was wondering about the various standards of distribution. How can I make sure that the independent trustee knows what my children should receive and what my thoughts are about limiting distributions to my children? And I said, well, we can take care of that in the documents, but also through the use of a memorandum of intent or a letter of wishes. So remember, if the decedent has left a memorandum, we need to look at that. We need to look for it and either attach to the back of the trust or maybe somewhere in the attorney's office. Hopefully it would be attached to the back of the trust. And that's guidance to you as the trustee or the fiduciary. And so we want to make sure that we're looking for things like that and we understand that they exist. So again, we want to encourage organizational tools, encourage education, which is why you're on this video today. We want to encourage a systematic approach. We want to disseminate information quickly and broadly. And we want to instill professionals to want to instill confidence. And you as a fiduciary want to instill confidence in the beneficiaries, in the people who are counting on you to administer the estate or the trust. And if you don't have that confidence, of course, you can extrapolate and get that confidence through your absolute ability and your right to hire professionals. So remember, you as a fiduciary, you have the right to hire professionals to represent you, and you should, as a general rule of thumb, to make sure that you are performing your duties. Now, I'm going to go back to our examples in the time that we have left, and we're going to work through them as promised. And Jeff, I'm going to stop for just a minute and see if we have any questions.
Thanks, Steve. We do have a question. The question is, are beneficiaries allowed to see all life insurance policies? People change their beneficiaries and may not have informed former beneficiaries.
That is a great question. I would like to talk to you offline on that one, but my initial reaction is that the beneficiaries would have the right to see that if they asked for it. And even if you took the position that that's not part of the trust or that's not part of the probate because it was life insurance and it passed outside of probate, my thought is that you would want to nuance that very carefully because someone could discover, and that's a legal term, someone could discover the existence of that life insurance policy or what happened prior to death with beneficiary changes by petitioning a court and asking for what is called discovery. So I think that's a very, very touchy situation where you have to weigh the ability of this person to discover that information versus revealing that information. Generally speaking, I would think you would not reveal that information. But again, that's without that person having to come forward and prove that they have the right to see it. So you probably wouldn't hand that over too easily, but every situation is different. That's a great question.
Thank you, Steve.
All right, so and the last few minutes that we have, and Jeff, how long are we going today?
We can go up to 11:45, Steve.
All right, so we have plenty of time. I thank you for your patience and your endurance as you hang in there through this material. So hopefully you're getting something from this. So now I'm using the critical dates checklist. This is the estate checklist, and it's the one at the top where it says personal representative. So remember, in Maryland, we call the executor the personal representative. And in some states, that personal representative is called an executor. So it's the same thing, it's synonymous. Now, notice that we have this gentleman, Felix. He was single, he died with a will, he had one child, and he had a simple will with outright distribution. So if we take the checklist, what do we know? Well, we have a date of death. We are going to go to the Register of Wills and we are going to petition for probate. We are going to either complete the petition for probate ourselves or with the attorney, or we're going to go to the Register of Wills and make an appointment, and they're going to complete the petition of probate for probate for you. So we're going to go there. We're going to be issued letters of administration because we're making the assumption here that Felix, in his will, he listed his personal representative. So let's just assume that that was Charles. Charles will go to the Register of Wills and say, I'm listed in my dad's will. I'm his personal representative. I want letters of administration. Now notice if you're looking at the checklist, it says the inventory and the information report is due in 3 months. Now let's talk about what that is. Remember, we have to get date of death values. So in that 3-month period, which sounds like a long time, from the time you opened the estate, you were issued letters of administration, and what did you do with them? You used those letters of administration to find out everything that you can, to go to the bank and take charge of that $200,000, to start selling the property or getting access to the property, because remember, Felix died as a single person. So if you were in this situation, or my example, Charles has the authority, if he didn't already have a key to his father's house, he has the authority to use the letter of administration to get a locksmith to open that house, go in, secure it, change the locks, and secure the tangible personal property. Now, Charles is going to go ahead here and get an appraisal of the residence. Now, we're talking in very general terms here. Sometimes it is possible to use the assessed value, but I'm going to go in a very high level here and say most of the time we are getting an appraisal of the property. Charles is going to inventory what the savings, checking, and CDs were worth on the date of death. He's going to get a value for the IRAs. He is going to value the savings bonds on the date of death. Okay, now let's look at the savings bonds. We're making the assumption here that there was no joint owner and that the savings bonds were in Felix's name. Now, we're not concerned about lifetime gifts because he had none. He did none. But what would Charles be prudent in doing? Well, he would be prudent in checking with the IRS to make sure that Felix filed all of his tax returns and that there were no outstanding balances at the date of death. So that's something that he would do his due diligence on in a perfect world, okay? And as a personal representative, he definitely would do that. So looking at the checklist, let's say Charles has done that. So now he's going to submit his inventory. His inventory is going to show the appraisal, the statements of value. He's going to submit that to the Register of Wills. Now, what is this information report? Well, the information report is a simple form that has not so simple questions. It has 4 questions, And it's basically trying to find out this. Did Felix give away assets prior to his death to it, or did he leave assets at his death to anyone who is subject to inheritance tax? Now that's a mouthful. So is anyone who Felix gave money to at death or 2 years prior to death, is that person subject to inheritance tax? And the answer is no in this case, because Felix left everything to Charles. Charles is a lineal descendant. He is a child, so he is not subject to inheritance tax. So therefore, Charles is going to say no, 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 no. Very, very simple on the inventory. And he submits that. There's no inheritance tax due. Why is that a big deal? Because the Register of Wills collects inheritance tax. If you did not know that, that is another function of the Register of Wills, and that's why they have that form. Now, in this estate, we're not worried about spousal elections. We are worried about claims of creditors, though. So when when Charles opened this estate, the Register of Wills put out notice, and so you know this by seeing newspapers or electronic newspapers these days, that such as the Daily Record or another publication, Charles has put notice in the newspaper through the Register of Wills saying that he's the personal representative and that creditors have a right to make a claim. So here there are no creditors. No creditors make a claim against this estate in the first 6 months. Remember, they have 6 months to do so. There is an alternative way to notify creditors, but I'm not going to get into that today. The typical way of doing it is to notify them. They have 6 months. Now, let's say that a creditor claim did come in. Let's say Felix had a Bank of America. I'm just making this up. They had a Bank of America credit card. Well, from my experience, I guarantee you Bank of America will make a claim against that credit card. So let's say it was a $1,500 balance. Bank of America makes that claim. Charles has the right as the personal representative to say that that is not a valid claim. But if it is a valid claim, of course, he has to pay it. So if Bank of America makes that valid claim, Charles has to pay that before he can distribute the final administrated assets. So that's a little bit about the claims of creditors. Now, I'm skipping way down this list because this is a very straightforward estate. We have the first administration account due within 9 months. So Charles, either himself or through the help of counsel, he is going to prepare a first and final administration account. He is going to submit that to the Register of Wills. Now let's go back up to the assets. During that 9 months, Charles probably, not always, probably sold the residence, and he put the $300,000. Now, of course, there are fees, there are realtor transaction fees, and so forth, taxes. But Charles, let's say, sold this residence. He puts the $300,000 in an estate checking account. So back when he opened the estate, he opened an estate checking account. He got a tax ID number, which the attorney or Charles would have obtained, or the CPA, and he has an estate account. And remember, Uncle Sam wants to know what is the income tax from the date of death until the date of distribution. So Charles is going to file a Form 1041 from the date of death until the time of distribution through his attorney or his CPA. Checking and savings, he's going to have closed those accounts and put those in estate checking typically. The IRA, Charles is the sole beneficiary. He's going to make a death claim on that IRA. Now, when that pays out to him, because there's no indication here that Charles is disabled, so he's not exempt under the Secure Act. So he's only going to be able to establish his inherited IRA for 10 years or less. So Charles will probably establish a $400,000 inherited IRA, and then he will take distributions or take assets from it. He has to deplete that within 10 years. The savings bonds, Charles is going to probably cash out these savings bonds because they are part of probate. They had no joint owner and no payable on death beneficiary. So these were owned by Felix. They are part of the estate. Now, there are income taxes due when Charles cashes out these savings bonds. So Charles is going to handle that by talking to his CPA and saying, or to the attorney, how do I best deal with this pretty large amount of income tax that's going to be due? Because this is kind of like an IRA, the income tax is due. So Charles is going to allocate possibly some of this income tax to his father's final income tax return. He's going to allocate some of it to the estate income tax return, and he's going to allocate some of it to himself to try to minimize the impact of the income tax on the savings bonds. We're almost done here. Charles notified Social Security, or the funeral director did at the beginning, and pretty much he's the only beneficiary, so there's not going to be any objections to his accounting. And after 20 days, the orphans court approves his accounting, and now he can distribute assets to himself. As part of all that, of course, he filed his father's final 1040 for the year of death. So that is a very quick overview of probate for this particular person. And I want to make sure you're getting something out of that. I'm going to keep going now. That took us about 7 or 8 minutes. Let's go to the fact pattern now of Jack and Janet. Remember, Jack and Janet were married for many years. Jack has passed away. Janet is the survivor. She has 3 healthy children, and there was a revocable trust. And it does not matter whether this was a joint family revocable trust or 2 separate trusts. It does not matter. For our illustration, everything went outright to Janet in our illustration here, and at least the first illustration. Now, I'm pulling out the trust administration checklist, and many of you are looking at this and you're saying, wow, this is fairly similar to the estate checklist. These checklists are not exclusive to Elville and Associates. You might be able to find other checklists, but these are good rules of thumb, good samples for you to start with. So what are we concerned about here? Well, all of those non-technical things that I talked about in the presentation. We want to make sure Janet is having support. We want to make sure she's not feeling rushed. We want to make sure that the children are all getting along, and if they're not, we want to be aware of that. We want to make sure she has that support. Now, the residence was in the trust or trusts, it doesn't matter. So now Janet is going to be the 100% owner of that residence. And we're going to go down the asset list here. But remember, Janet is going to do a little bit of administration, but not a whole lot here, because Jack wanted things to be simple. He wanted everything to go outright to Janet. So what's going to be involved here? Well, Janet, there's no indication she's not healthy, so she's probably the successor trustee. So she's going to retitle the residence to her trust, because everything in our example here is outright to Janet. She's going to take charge of the checking and savings if that was not already joint. If that was not already joint and in the trust, she's going to take charge of it, make sure that it's in her trust. She's going to make death claims on the 401k and the IRA. And we know that Janet is probably going to roll over this 401k to an IRA. And remember, in the next example, that's how she ends up with such a large IRA. So she's going to roll this over to her own IRA. She does not have to take minimum distributions or pay tax. She's just going to take charge of that IRA by putting it in her own name as her own IRA with her financial advisor. The brokerage account that was in the trust, she's simply going to make sure that all of that now is in her surviving revocable trust for herself. She's going to make death claims on the life insurance. The life insurance could be beneficiary designated to her, or it could be beneficiary designated to the revocable trust. In any event, she's going to take that cash and she's going to put it in her trust. The Delaware resident, she's going to do the same thing as she did with the, let's say, the Maryland residents in our example. She's going to put that in her sole name in her own trust. Now, Jack and Janet never made any lifetime gifts. Social Security income, Janet is entitled to the higher of her income or Jack's income. Let's pretend this was Jack's income. She's going to make an appointment with Social Security. She's going to get his survivor amount of Social Security. Now, notice that many of the things here are exactly the same as in the probate estate, but because there's a surviving spouse and because the distribution is outright to Janet, meaning outright to her or to her own revocable trust, there's really not a big amount of administration to do here. Janet just needs to walk through some of these basic things and get everything over to her own name and continue on with her life. Now, we know, even though I didn't add up all of these assets, we know these assets are less than 11.58 million. So Janet is going to talk to her attorneys and CPAs. she's going to say, should I make the portability election? Should I go ahead and elect Jack's 11.58 million? And I already have my own 11.58 million. Should I do that? Well, gee, I don't have anywhere near 11.58 million. So why would I need both of these? Why would I need 23 million in exemption? Well, my opinion, subject to the facts and circumstances of this particular case, would be to go ahead and make the portability election, because we all know that President-elect Biden has proposed to cut the estate tax exemption. And of course, we do not know what's going to happen with the Georgia runoffs, who's going to control the Senate, whether it's the Republicans or the Democrats. We don't know how easy it's going to be for the Democrats to push through what is being proposed as a reduction from 11.58 million, supposed to be 11.7 million in 2021, down to 3.5 million or 7 million per couple. So here it is a judgment call, but even though it would be somewhat expensive to go ahead and have a Form 706 prepared to make the portability election, we know that, being very conservative, Janet probably should go ahead and make the portability election, because we know that the IRS has had a ruling, a regulation that says if Janet uses portability, if she ports Jack's amount, that can never be taken away from her. So this might be a conservative play to make sure that even if the government lowers its exemptions, Janet is making the portability election for Maryland purposes and federal purposes, so that she's never exposing any of the assets to the federal estate tax or the state estate tax. Now, back up to the top again real quickly, and looking at the checklist, the trustee is going to go through the same motions as the personal representative. We want to get the date of death values. We want to establish a trust account so that we can put assets in that trust account. But in this case, because it's a surviving spouse, the process is a little simpler. When we get to the death of Janet, which is the next slide, now we're seeing the death of the surviving spouse. And many of these principles of what happens at death become a little bit more stringent versus the kind of easy transition that we had here between Jack and Janet. This is an example of the utility and the wonderful ease of administration that usually happens with a revocable trust. Last point on this fact pattern, the formula clause. Let's look at that down below there. Let's say that at Jack's death, his revocable trust said, I'm not leaving everything outright to Janet. I'm leaving everything in a trust, either a Q-tip trust or a marital trust of some kind, or a family trust, or what is sometimes used as, in modern terms, a bypass trust. That would be somewhat of a formula clause, whether it's a traditional formula clause or just a straight marital trust, as we might call it. That means that Janet's administration would not be quite as simple. She would have the responsibility of setting up this family trust or this marital trust, because Jack said, I want to provide asset protection for my spouse and a further trust, and I also want to prevent remarriage and these assets going to a new spouse. So that we're not going to get into that today just because of our limitation on time, but just know that if Jack had provided for a formula clause or a marital trust of some kind, then Janet's responsibilities here would include setting up that new irrevocable trust for her benefit. And in addition to that, she would have her surviving revocable trust. So just know that it wouldn't be quite as simple as just putting everything over into her trust. Last point on this. If Janet had, in the first example, just put everything over to her trust, we would want to make sure that as she is taking possession of the assets that she's inheriting from Jack, we want to make sure that she does not need to disclaim any of those assets. Now, we've had huge exemption amounts and we've had portability for such a long time that this idea of disclaiming assets at the death of one spouse is not something that happens as frequently, although we may see it much more in the future. So if we did not have these huge exemption amounts and we had much smaller amounts, we might be using a disclaimer that the assets come to Janet outright, but she's disclaiming, which is a tax, it's usually a tax election, to establish a family or bypass trust, which is beyond the scope of our discussion today. So just know these kinds of tax elections should be considered and must be considered before assets are claimed or taken over by a surviving spouse, such as claiming life insurance. All right, I'm going to look at my time, make sure that we end on time. We're a little bit past 11:30. I think we'll end by 11:45. This is a similar fact pattern as you may remember, except Janet now, 20 years later, has died. So now her successor trustee is going to administer her estate. I direct your attention back to the checklist. That trustee has got fiduciary responsibility. This person is not only responsible to the trust itself, but to the beneficiaries, to the two siblings that he or she has. And one of those siblings is brain injured. This person has a disability now. So things have really changed. So what are we looking at here? That trustee has to get date of death values. Sound familiar? It's almost like probate. We have to get date of death values. We have to establish a new tax ID number for Janet's trust, because now the trust is going to report to Uncle Sam from the date of death until the date of distribution. That's going to require a Form 1041. The trustee should do some kind of inventory. It's not a formalized inventory like with the Register of Wills, but nonetheless, the trustee is going to account for all assets, including the deposit at the CCRC. So the trustee is going to start the process of an accounting, even though there's no formal jumping through hoops at the Register of Wills, because in the end, no matter how short of time or how long time this trust administration takes, at the end, this trustee is going to be responsible to his or her two siblings. So let's walk down through the checklist and also through the assets. So the trustee is going to notify the CCRC of the death. Of course, they may already know that because Janet lives there. And what do we know about the CCRC? A typical CCRC in a situation like this would be refurbishing the unit and selling the unit or renting the unit to someone else. So this refund is, depending on the contract of the CCRC, this refund is going to come back to the trust, and that may take several months, depending on what that contract is, if there is a refund, minus many times a refurbishment fee is going to come back. So the trustee is going to have to hold the trust open long enough to receive this money back, okay? And of course, during life, we would want to make sure that the CCRC form has been properly filled out to say the deposit goes to the revocable trust. We don't want the deposit to go to probate. I'm going to take a drink of water, please. The trustee is going to take charge of the checking and savings and CDs, put that cash into the trust checking account most of the time. The trustee is going to make sure that claims are made on the IRAs. So remember the three siblings, in our example, they are getting equal shares. Her trust was very straightforward that it's equal shares, but it's in further trust. So the successor trustee here is going to make the death claims in a timely manner before the fall of the year following death, starting in September, October. So in September, the beneficiaries are identified. By the end of October, the custodian has to receive the plan documents. They have to receive the trust, I should say. So the trustee here has to provide a copy of the trust to the custodian, and then that trust, meaning the IRA, has to be separated into 3 shares by December 31st of the year following death. The brokerage account, the trustee is going to take charge of that, is going to retitle that into the name of the administrative trust with the new tax ID number. Now, the trustee is going to decide, do I liquidate all those assets? He probably should, unless the beneficiaries want to take those assets in kind, because what do we know? The assets could fluctuate up or down, and the trustee has to protect themselves. They may very well liquidate those assets and make sure they're safe. Life insurance, he's going to make a death claim. The Florida residence, he's going to sell that probably, he or she, or he or she is going to ask the siblings whether they would like to buy it. Now, notice at the bottom, we have this issue of the assets are going into further trust. So after we start with the date of death values and the trustee has accounted for and valued all the assets, he's gotten appraisals, he's gotten date of death values of the brokerage account, he's got appraisal of the Florida residence, he has properly valued the amount of money that's supposed to come back from the CCRC. He or she has done all of those things, okay? And now what do we have? We have a situation where one of the beneficiaries has a brain injury. And this trust that Janet provided, she did not know that at the time of her death, this beneficiary was going to be brain injured. So this is a regular, or what I would call a general needs trust for this beneficiary. And now the trustee might want to have that trust decanted. Maryland does not have decanting, which means taking one old trust, turning it into a new trust. So the trustee might use the laws of Delaware or Virginia or one of the other 20 or 22 states that has decanting to change this beneficiary's trust into a special needs trust if that situation required that that beneficiary probably should not have a general needs trust. All of these things have to be done. At Jack's death, Janet had filed tax returns. In a certain scenario, she might have elected portability. So now the trustee just has to wrap all of that up. They have to get releases of liability. They have to notify Social Security. And then after they've gotten those releases, even though they're siblings, and after they've done, he or she has done the decanting, and he or she has addressed all of the potential issues of this trust administration, which could take quite a while because of all of these ancillary issues. This is a little bit contrary to what we want, right? As people who are doing revocable trust planning, we want something that's going to be quick and easy and low cost. Well, here we have some outlying circumstances that may require that the trust be held open for a little while to get these things done that were not expected. So hopefully that gives you an idea of what would happen on the death of a surviving spouse. So the surviving spouse in this situation, Janet, could have had a revocable trust where there was no family trust, no marital trust that Jack had established for her. So it's pretty straightforward, and this checklist will serve as guidance for you. Or we could have an administration like this where there is a family trust or a marital trust that has to be distributed. There is a injured beneficiary that has to be dealt with. And let's talk real quickly about the IRA share for that beneficiary. And I know we're running out of time. The IRA beneficiary here, the IRA is coming to an inherited IRA for this injured beneficiary. So what do we know? We know that if that IRA goes into a special needs trust, that beneficiary is going to be able to stretch out the required minimum distributions, whereas a healthy beneficiary is limited to only 10 years. Or if this trustee had not paid attention, or if this trustee had not followed the rules of the road and had gone ahead and distributed this IRA to a disabled person without a trust, well, at least we know that under the federal law, an inherited IRA can be approved to be put into a different kind of special needs trust without having to incur taxation. So these are reasons why, under circumstances such as these and many others, you probably would want legal guidance as the fiduciary to make sure that you're on the straight and narrow. And in the interest of time, we have about 3 minutes, Jeff. I'm sorry, we've gone right up to the time. We're going to go to the fact pattern where we have this interesting situation where we have no estate plan. So if we go back to the probate checklist, what is this going to mean to us? Well, we have a spousal situation, but one of the spouses might not even be reachable. So if you're a personal representative under an unusual fact pattern like this, remember Ricardo had no will, so he's still going to have probate. So you're still going to have to petition. Now, he did not have a will, so he did not name a personal representative. So the issue here is we've got children, we've got a surviving spouse. Someone is going to have to come forward and be appointed because we have no will. That's called judicial probate. So hopefully, if you were administering this estate, you'd be able to gather enough information and have enough contact with the children and the spouse that you could get consents from them about one of them serving as personal representative. And if you couldn't get consent, you would just petition the court and ask the court to appoint someone. So the $3,100 is in probate. We have to open an estate checking account. We have to take charge of that money after the letters of administration are issued. The inherited IRA is going to be distributed out to the beneficiaries. If Ricardo has no beneficiaries on this inherited IRA, it will be paid to his estate, most likely. The automobile is $11,000. That's going to be in probate because that was in his own name. The life insurance here is going to be beneficiary paid to the estate because it has no beneficiaries, what I was trying to say. And now a non-probate asset like life insurance is now unfortunately going to go into probate. So that's an example there. The savings bonds are subject to probate. So that's similar to the other example, okay? So we've got 177,000 of savings bonds. Those have to be cashed out and distributed. The lifetime gifts of 500,000, well, we know Ricardo used some of his lifetime exemption. He used some of his 11.58 million exemption, but because he had so much exemption, that does not matter. So I just wanted to throw that out there that he did use some of his 11 million exemption, but it won't matter. The personal representative will contact the pension company and make sure that they're aware of Ricardo's death. Now, as we wrap up, and I know I'm right up against the time to stop, and thank you for your patience. Here we have a surviving spouse. Now, the surviving spouse is entitled to a certain amount of the assets by Maryland law. It's roughly 50%, and we won't go into the details of that. And the children are entitled to the other 50%. So Maryland law of intestacy, like most states, is going to dictate here how the surviving spouse gets his or her share and how much the children get. So this is what we're dealing with in this estate. We have no will. We have a survivor. We have to give notice. Hopefully all the beneficiaries can be notified. Hopefully they are cooperative, but there are some nuances here about how everything is going to be distributed because there's no will, the law of intestacy is going to take over. All right, and I know I'm past our time. I did my best to deliver as much information as I could to you today. I hope you got something out of those examples. I hope I've satisfied many of you who wanted to work more closely through actual examples instead of me giving you, just an overview of some of those fact patterns. And I encourage you to not be confused, not be frustrated, not be mystified by these processes, but to work through a checklist, work methodically, sit down with me or sit down with our estate and trust group, which is quite talented. Let us counsel you through these issues and help you, and we're here for you to be a resource. And making an appointment is very easy. You can make an appointment with me by email, steve@elvilleassociates.com, or my assistant, Mary Gay Kramer, mary@elvilleassociates.com, or through our website, or through Jeff, who's going to be on the call here just a few more minutes. And again, thank you. Happy holidays to you. And Jeff, I'm going to turn it over to you. Thank you for being a great moderator.
Well, thank you for being a great presenter, Steve. A lot of great information. I know if I had to administer a state, I would certainly not go it alone. A wealth of information. Do you want to take a question or two? We do have 2 questions.
Yes,
or
sir.
I can forward them to you by email. Okay. So the first question we have is, a living father does not want his adult daughter to inherit anything. His lawyer added an amendment to his revocable trust. Does she have to be notified, and if so, when?
All right, that is a great question. If I understand this, a trust was amended, and it disinherits a child. And the question, I think, is, does the child have to be notified? Well, qualified beneficiaries have to be notified. My initial reaction is that she would receive notice. Now, that's my initial reaction. I'd have to look at the Maryland Trust Act just to make sure I'm answering your question correctly. And if you wouldn't mind, please send me a message, Steve at Elville and Associates, elvilleassociates.com, and I will give you a more precise answer on that. The issue there is we want to be clear that she's disinherited, and that's a difficult thing to do, but it needs to be very strong in many cases and needs to be very clear. My initial reaction is she would be entitled to notice because she would be considered to be a qualified beneficiary, but I am going to invite you to send me a message so I can be more precise about that.
Thanks, Steve. Last question. Are beneficiaries allowed to see all life insurance policies? People change their beneficiaries and may not have informed former beneficiaries.
Well, I think this is a great question as well. So under Maryland law, there is no such thing as a quiet trust. Now, I know you're talking about life insurance, and you may be talking about a situation where the person has a will and does not have a trust. You may be talking about a situation where even if there is a trust, the life insurance is not paying to the trust. It may not be involved at all with a trust situation. The life insurance passes without probate. It's a non-probate asset as long as it has beneficiaries. The issue there is that any person can petition if they have standing. Any person can petition to see non-probate assets. So we know life insurance should be, unless there's no beneficiary, should be a non-probate asset. So my answer is initially no, they would not have the right to see all information in the sense of asking to see life insurance policies. And I probably shouldn't have used the word have the right. Initially, they wouldn't be thought of to have the ability to just request life insurance policies and take a look at everything. But the thing to remember is that even though they do not have the right, in my opinion, to be writing or calling you up and asking for life insurance policies, ultimately, if you don't reveal information, someone could petition a court and ask to see or to discover non-probate assets. So you have to weigh kind of keeping this information quiet. If it has nothing to do with the trust, you could probably keep it relatively quiet because it's not part of probate. But on the other hand, someone could discover non-probate assets in a court proceeding. So I hope that helps a little bit. It depends on the context of how these life insurance policies are owned and where they're payable to upon death. So that's another thing we could talk about offline. Thank you for that question.
Thank you. Okay, so we are at 11:50. Thank you, everybody, for staying on, and a lot of great information shared by Steve, as always. So we are coming up on the holidays. We do have another webinar coming up next Wednesday as we wrap up here, the financial aspects of estate planning, offered by our senior principal here, Olivia Holcomb-Volke. That's next Wednesday at 10:30, so that's one you don't want to miss. We've got a big crowd for that one. Please consider us a resource here at the firm for your family's planning needs. It's always our goal to create solutions for your needs here, give you a path forward, and I think that always offers peace of mind for you at the end of the day. That's the goal of our attorneys here at Elville and Associates. So Steve's given you a lot of different ways that you can get in touch with us. I'm going to stay on for a few minutes afterwards if you have any non-legal questions. I'm not an attorney, so let me know if you have any questions related to our firm, how we can help you going forward. So we have a very busy January going into the new year with a lot of new webinars. Very excited about that. It's going to remain our goal to educate going into the new year and further our commitment to do that. And also, if you have a few minutes, please do fill out that post-webinar feedback. This is a quarterly webinar. We value your feedback in how we did today, and I'd like to thank Steve for his time today and yours as well. So happy holidays to you for those celebrating Hanukkah. Happy Hanukkah to you as well. And we hope to see you again soon on our Elville webinar series. Have a great day, everybody, and a great weekend. Take care.